everybody. My office is part of the New York City Law Department, which is basically the city's law firm. The office itself is comprised of numerous divisions that handle all sorts of legal work for the city. One of those divisions is the division that I work for, which is called the Family Court Division. Most people don't realize that we even exist. My office handles the prosecution of juvenile delinquents. Those are kids that are arrested for crimes that allegedly they committed between the ages of 7 and 15. We have jurisdiction over most of those type of offenses that are committed by kids in that age range. However, the Family Court Act does establish what's called the juvenile offender status for certain higher level crimes committed by kids the age of 13, 14, and 15. Some of those crimes are handled by the district attorney's office as juvenile offenders. For example, if a 15-year-old commits a robbery in the first degree, that's where they would use a weapon, or say they rob someone at gunpoint. That case would be handled by the district attorney's office. My office would handle cases of a robbery in the second degree where there was no injury caused to the victim, but if it was an in concert offense, meaning 2 or more people committed the robbery. But generally speaking, most crimes committed by kids in that age range are handled by my office, out of the Family Court. Now, the Family Court is a quasi-criminal proceeding in family court. The juveniles that are arrested are not called defendants, they're called respondents. We use different language in family court to acknowledge that these are actually kids that we're dealing with, mostly junior high school kids, but they're kids. And they're arrested for committing an act that if they were an adult would be considered a crime. When a juvenile gets arrested, and when I say juvenile, I'm referring to this age group specifically. When a juvenile gets arrested, that case comes to the family court, but I don't get the first bite of that case. The first bite goes to the Department of Probation. The Department of Probation has the ability, under most circumstances, to hold that case open for adjustment or decline it completely. The Department of Probation contacts the witnesses and the victims, speaks to the respondent and their family, and determines whether or not it would be more appropriate to offer adjustment services in lieu of court action, in lieu of referring a case to my office. And probation does that quite a lot, particularly on low-level offenses, particularly for kids that have never been arrested before, or cases where the victim wants just the child to get some sort of services in the community. And probation will offer those services. If for some reason the case cannot be adjusted or there's a failed adjustment, the child doesn't cooperate with the services that are offered, then the case comes to my office. In Manhattan, we're located at 60 Lafayette Street in the Family Court, which is literally across the street from 100 Center Street, where the DA's office is located and where the criminal court is. I have in my office, I run the Manhattan office. We are actually the 4th smallest office in the city out of the boroughs. 4th is Staten Island being the 5th in terms of the amount of juvenile delinquency crime that we see throughout the city. I have, I believe on staff right now, 10 assistant corporation counsels. Those are the prosecutors, but we're called ACC's Assistant Corporation Counsel. And once a case is referred to us, one thing that we look at is the youth's prior history, school history, information that's provided by the parent, the level of the crime. And we investigate those cases, and we interview all the witnesses, and if we can, and if the circumstances are appropriate, we will file the charges before the family court judge. Once the case goes before the family court, there's no bail at all. There's no such thing as bail in family court. What they do have is what's either parole or remand. The court, when a youth comes before the judge, every time, the first time they come to court, but then pretty much each and every time they return to court, the court has to make a determination whether or not the youth should stay in the community. And the factors that the court considers is the likelihood that the child will offend again, and whether or not there's a risk that if the child is paroled, that child will not return. The court also considers the serious nature of the offense that's committed. So those are the factors that the court uses to determine whether or not the youth should be paroled to an adult pending the case or should be remanded. Most of our kids get paroled. Some don't, and some wind up going to a juvenile detention facility in the city. Some go to a secure facility pending the completion of the case, or some will go to a non-secure facility, which is more like a group home setting. And it really depends on the child. The court makes that determination in conjunction with information provided by the Department of Probation. In every courtroom that handles juvenile delinquency case, there is someone from the Department of Probation who reports to the court about the child's history, about their schooling, whether they've been suspended, if they've been arrested before, and all that information is provided to the court so that they have as full a view of the youth as they can. And also the guardian has the right to advocate or not advocate for the youth. Sometimes mom will come in and say, my son is out of control, I don't want to take him home. And the court will make a determination based on that information. There are a number of differences between how we process cases than the DA's office. We have a very strict speedy trial requirement. The DA's office can put off cases, in a sense, if an adult is paroled for months and months and months. We cannot do that. Once we file the charges, we have to commence the trial within 60 days. If a youth is in detention, if youth have been remanded to the court, we may have to commence that trial within 14 days from the initial court appearance. That's very, very quickly, which means, and in order for us to file the charges, we have to file what's called a non-hearsay petition. So we have to have statements from all the witnesses to support that petition. It's different from the adult system where you have a period of time to convert a complaint to non-hearsay. We don't have that luxury in family court, so it's a very, very, very quick process. So my ACCs need to move very fast on getting cases before the court and getting them to completion. We do also have the ability to go to trial fairly easily as long as we have full cooperation from our witnesses and can turn over the materials that we need to the child's attorney. We don't have juries in family court. We only have a judge. And in Manhattan, particularly, there are 2 judges that only handle our cases. There are a couple other judges that will handle some of our cases if necessary. But these 2 judges are very experienced and have been doing these cases for years, and they understand the practice and move things along as quickly as possible. The goal of the family court, and which is guided under the Family Court Act of the state of New York, is not punishment. We're not allowed to punish. It's not a factor that we can consider in deciding how a juvenile should be sentenced. The court, when determining a sentence after the child either pleads guilty or is found guilty of what we call a finding, we don't call it conviction, we call it a finding, the court then has to make a determination what should happen to that child. And what they need to consider is the least restrictive alternative, taking into consideration the safety of the community and the best interests of the juvenile. It's all about protection of the community and rehabilitation. It's not about punishment. We don't sentence kids or give them a disposition because we don't like what they did and they need to be punished. It's a factor. The serious nature of the crime is obviously a factor, but it's not what necessarily motivates the sentencing or the disposition, is what we call it. And when we get to that point of the disposition, the court orders what's called a report. They get reports. The Department of Probation gives us a report about the use history. They interview the family. They interview the victim and any eyewitnesses. They get school records. And sometimes the court will also order a mental health study. There are psychologists and psychiatrists on staff in the family court who will do an assessment of the youth. And probation and the mental health clinic will make a recommendation as to what should be done with the child. Now, for sentencing alternatives, the court can do a number of things. The court can dismiss the case outright and say this child does not need any supervision and dismiss it outright. The court can give the child, the youth, an adjournment and contemplation dismissal, meaning if they stay out of trouble for 6 months, the case then gets dismissed. If they do something in that period of time that they shouldn't have done, then the case can come back and the court can issue a new disposition. The court can also grant a conditional discharge for 12 months, where if they stay out of trouble, they don't have to see a probation officer, but after the 12-month period, the case is over, but it doesn't get sealed. The court can also put them on probation, and there are different types of probation. The court can issue probation for up to 24 months for most type of cases. And the different levels of probation supervision, they're different. So depending upon the need of the child, that the level will be determined and ordered by the court. Or as a last resort, the child could be sent to a juvenile facility, either a non-secure facility or a limited secure facility, or in the most serious of cases, possibly a secure facility. If it's a misdemeanor finding, the initial placement period is 12 months, with the court's ability to renew that up to the age of 18. If it's a felony, generally speaking, it's 18 months with the option to renew to 18. However, if it's a designated felony, the court can actually do it for a 3-year period with an option to renew to 21. That happens very infrequently, but that does happen. We also have the ability to send a child to the Office of Mental Health if there are psychiatric issues. So for the most part, most kids wind up going into a less restrictive probation. Not that many kids go to placement. The placement facilities are generally run by the state, or they're contracted, they're private agencies that take the children. We don't get a whole lot of cases out of Roosevelt Island, which is a good thing, assuming that the kids that are committing crimes are getting arrested. But we're just not seeing a whole lot. Remember, most of our kids are middle school age. We have some high school kids, but not that many. We do work hand in hand with the DA's office. Particularly, we share information with one another. We provide them with information on an adult or a youth 16 or over regarding their past family court history, and they share information with us too. So we're constantly in contact with the folks at the DA's office. Yes, sir, in the white shirt. No, ma'am, I'll get to you.
What would you say the most common reason for arrest is for a case that comes to your office?
Well, we get a cross-section of stuff. Any type of crime that an adult gets arrested for, a juvenile gets arrested for too. So we see, I think a lot of the cases that are getting adjusted by probation that we're not seeing are sort of the first-time shoplifting cases, marijuana possession, graffiti, maybe an assault, regarding a school where the victim wants some sort of adjustment or mediation services, that kind of stuff. But we do see our share of robbery cases, grand larceny, we see a lot of cell phone snatches, iPhones, some school cases, school assaults.
How many are that kind of crime? Physical, assault related person to youth to youth or youth to someone else versus, property or drug and that kind of thing?
In terms of percentages, I'd just be guessing, and I don't want to throw out any figures. We see all of it. What the breakdown is, I couldn't say. Yes, ma'am.
Okay, you say 7 to 15, you said those are juvenile, and you call them respondent.
Right.
So you're saying the 17 to 15-year-old group, that age group, you're classifying them as being minor, as minor. 16 years old would constitute them to be an emancipated minor. And why is 16 is the ambiguous year
Well,
between
it's
a
actually,
minor and emancipated minor? So at 16, you say that they are emancipated minor and they can be charged as adults?
no, it has nothing to do with emancipation. It has to do with the Family Court Act. The Family Court Act has jurisdiction for kids 15 and under.
But one time you used to go to 16, so why did they stop at, why did they drop it to one age limit?
It's been under 16 for many, many years. In fact, there's a movement now where there's consideration of giving the family court jurisdiction over 16 and 17-year-olds. That would have to be a legislative change by the state. But it's been under the age of 16 for probably 40 years. I mean, since the Family Court Act was enacted, I think in the early 70s.
And so since the Sparkford has closed, where are your cases that the 16 over, are they still going to Rikers Island or are they going to the New Horizons up in the Bronx? Where's the juvenile from Sparkford during the closing of Sparkford? Where are those kids being sent now?
My kids go to Bridges or Horizon. So those are the two facilities that created instead of Spofford, and they closed Spofford. I believe I'll defer to the DA's office to where the youth that they prosecute go. Do you have some in?
You know, I couldn't even say. I deal almost exclusively with adults.
I think they go to both.
Go to where?
Both, yeah. I think the age that the court looks at is the age when the crime was committed, not the age of the child when the child is before the court. So if the crime occurred when the child was 15, but they're now 16, it would still come to family court. So all those family court kids, even if they're 17 or 18 by the time they get prosecuted, are going to be at either Bridges or Horizon or the non-secure facility. The kids, I think, 16 and up who are being held on bail go to Rikers. But my kids don't go to Rikers. And there's other facilities that they're held at as well.
Well, I know the different homes and stuff that you have up in Bronx and Brooklyn, but you're not doing it in Brooklyn. But I know the group homes, they're also expensive allocated to recommended. So I'm aware of that. But I was only concerned about that age from 7 to 15, and then that ambiguous age of 16. What happens? That seems to be a big problem.
Well, as I said, if they're under the age of 16 when they're arrested, it's most likely coming to my office. 16 is most definitely going to the district attorney's office at the time that the offense was committed. Sometimes kids commit offense when they're 15 but don't get arrested until they're 16. That would come to me. Unless it's one of these really high-level cases that the DA's office has jurisdiction.
So if they're 15 and you're the high level, and they turn 16, you refer the case in.
I'm sorry?
If the child at a high level crime at 15, say 15 to 9, 10 months, doesn't get prosecuted to about 16 in 3 months, then you refer that case over to.
Well, the DA's office would have the initial jurisdiction, so the case would go to them directly. If a 15-year-old is arrested for a robbery in the second degree where there's injury, it automatically goes to the DA's office. I don't see that case. It goes to them. I may know about it because I look at the arrest reports. I look at all the arrest reports every day, but it goes to the DA's office.
So that will also hold true for somebody who's 14, 13.
It depends on the level of crime. Depends on the level of crime. If a 14 or 15-year-old commits a robbery in the second degree where there's injury, it goes to the DA's office. If it's a 13-year-old, it comes to me. But they may get charged as there's a whole, the family code lays it all out. There's a whole chart, which I didn't bring with me. But, it just depends on the level of crime and the age of the juvenile at the time that they're arrested as to who has jurisdiction. But to make it just simple, probably 90% of the cases that are committed by kids 15 and under come to my office. Some go to the DA's office, but most come to my office. or at least go to the family court. I may not see all of them because probation may dispense with them, but they go to the family court.
But it says 7 to 15 in Catholic Minor. How much parental input does the parent have in the situation? How much control of input does the parent have?
Well, the parent actually, from my view, has a lot of input. The Department of Probation interviews the parent to get the parent's perspective on what's been happening at home, and the court will inquire with the parent, and the parent has the right to inform the court of information that they may have about their child that might be helpful to the court. Ultimately, it's going to be the judge's, if the case goes to court level, it's going to be the judge's decision on what happens. But when a case is at the Department of Probation level, at the adjustment stage, the parent of the child is very involved. If probation deems that a case, say the child gets arrested for shoplifting first offense, the store will agree to adjustment services. The probation will only go along with adjustment services if the parent or guardian will agree to it. If the parent or guardian won't agree to it, then the case will be referred to my office, because you need to have a parent who's going to cooperate and get their child to participate. Sometimes you have it, sometimes you don't. It depends on the situation.
Okay, thank you, Karen.
Thank you.
I appreciate it.